Recording in progress.
Yeah. Something.
We can start, Dhanashree.
Okay. Good morning, everybody. So today's topic for discussion is the High Court case on Gujarat Chamber of Commerce and Industry versus Union of India. Firstly, thank you, Venu, for giving me this topic. I think it was a very interesting case law. I hadn't read it this way, and possibly I would have never read it this way because I would have, for presenting this, we go a little more in depth. And Jatin sir's book on allied laws, that gave me a lot of background or base to understand what was going on in the case law, because I was reading and it was all going above my head. So that was also extremely helpful. And Annapurna Kabra ma'am for bouncing off the thoughts and helping me get a better understanding of what I've understood also. So getting on with the case, what is happening here is GIDC, that is Gujarat Industrial Development Corporation, which is formed under the Gujarat Industrial Development Act. It has certain rights. It is a nodal agency for Government of Gujarat for the purpose of development of industrial estates in Gujarat. So this GIDC acquires land and creates some infrastructure such as road, water supply, street light, drainage, etc. And then it gives it on long-term lease to an industrial unit for building a building and then carrying on its business. So then this lessee or the assigner assigns these leasehold rights under the approval of GIDC to third party. This is the transaction. The first limb, that is GIDC transferring the lease rights to the lessee, it's very clear, and the case law is also agreeing, Gujarat High Court is also agreeing that it is supply. However, it is coming under notification 12, serial number 41, where it is exempt because long-term lease by government for industrial development, 30 years and above, is exempt. So it is not liable to tax. The first limb is not liable to tax. The question is the second limb, where the lessee is assigning the leasehold rights to third party under the approval of GIDC. Whether that is liable to tax or not is the question under the case. So I've already explained this. I'll just walk you through, saying the powers of GIDC is to acquire, hold such property, both movable and immobile, as may be necessary for the performance of its activities, and to lease, sell, exchange, or otherwise transfer any property held by it on the conditions as may be deemed proper by the corporation. So even once the lease is given by GIDC to the lessor and to the lessee, and the lessee gives it to the third party, the leasehold rights is given by the lessee to the third party, GIDC will still remain the owner and have all absolute rights under the ownership would be under GIDC. And these are all the rights of GIDC: right to own, construct, give a license, possess, occupy, give a lease, right to sue, right to compensation, and reversion right. I'll spend like half a minute on what is reversion right. Reversion right is a legal right that gives someone the right to retain the ownership and control of something after a set period of time. So basically, even after the after GIDC has transferred the lease rights to the lessee, the rights of reversion or the rights of ultimate ownership and remains with GIDC. So the question, as we have already understood, is the assignment, whether the assignment of leasehold rights of plot of land allotted on lease by GIDC and the building constructed by the lessee or successor, whether this transfer of this leasehold rights or the assignment of this leasehold right to a third party on payment of lump sum consideration, is it liable to tax under GST as a supply of service? That is the question. The petitioners have prayed that it is not liable to tax under GST, so don't charge GST. Or if GST is liable, allow ITC to pay the taxes. That's what they have prayed. These are all the submissions of the petitioner. So the transaction is clear, or anybody would like me to go into any of the specifics in the transaction before we go on to petitioner submission?
Proceed.
Okay. So the petitioner, first of all, talks about what is immobile property. They say that immobile property is not defined under GST law. And that's how they bring in the definition of immobile property as we know in Transfer of Property Act, Registration Act, and General Clauses Act. Under Transfer of Property Act, again, immobile property is not defined under means. It says immobile property does not include standing timber, growing crops, or grass. Registration Act defines immobile property as it includes land, building, hereditary allowances, right to ways, lights, ferries, fisheries, or any other benefit to arise out of land and things attached to earth, or permanently fastened to anything which is attached to earth, but not standing timber, growing crops, or grass. So it is an inclusive definition, and the highlight here, or the important aspect here for us to consider, is benefit to arise out of land and things attached to earth, or permanently fastened to earth, which is attached to earth. Similarly, our General Clauses Act also talks about immobile property as inclusive definition: land, benefits to arise out of land, and things attached to earth, or permanently fastened to anything attached to earth. So both Registration Act and General Clauses Act talk about benefits to arise out of land to be immobile property. And the petitioner says that this leasehold rights is a benefit that arises out of land, and hence it is immobile property. Section 105 of Transfer of Property Act talks about what is lease. Lease of immobile property is transfer of right to enjoy such property made for a certain time. So it is not a permanent transfer. It is for a specific time. The time could be limited, 1 year, 2 year, few months, or it could be in perpetuity. In consideration of price paid or promised, that is called as premium, salami, and such other terms, and or money or share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferee, to the transferor by the transferee who accepts the transfer in such terms. So there are two considerations. One is the premium, and the other is periodic premium, which is lump sum payment, usually lump sum payment, but can also be paid in installments. And the other one, which is the rent, which could be share of crops, money, service, or any other thing of value. So the petitioners or the members of the Gujarat Industrial Association have submitted that benefits to arise out of land are immobile property. So they say since immobile property is not defined in the GST law, general principles of law, to the extent they are not specifically excluded, are applicable to any enactment. We just read what immobile property means under Transfer of Property Act and Registration Act and General Clause Act. So they're saying that lease of immobile property is an interest in land. Lease of is an interest in land and building. And every interest in immobile property or benefit arising out of land will be immobile property for the purpose of 105, for the purpose of lease under Section Transfer of Property Act. Assignment of leasehold rights constitutes absolute transfer of rights in immobile property, which itself is immobile property. As such transfer extinguishes all the rights of the transferor. This is important. Such transfer extinguishes all the rights of the transferor in the immobile property and snaps any legal relationship with the lessor. and the assignee becomes liable for obligations under the lease deed. Vis-a-vis the lesser. Since the assigner steps out of the equation entirely due to sale, there is no element of service in the transaction. That's what the petitioners are submitting. They're also bringing in DLF commercial projects case by Sestat, which says that development rights are benefits arising out of land, hence not liable for service tax. Leasehold rights is in fact greater right and interest in the land than development right. And therefore, the principle under the service tax regime will continue to apply even the GST regime. This is their most important and potent submission, that the benefit arising out of land is immovable property, and this is absolute transfer in immovable property, and hence not covered under the definition of supply or for being liable to tax under GST. Then they say assignment conveys lessee's whole interest and it shall be transferred without having any reversion, without reserving any reversion. The question of calling the transfer an under lease or sublease is out of way. It is not sublease, it's a completely different rights that is being transferred. It is complete leasehold rights which has been transferred, so it is absolute right, and the lessee does not have any right to reversion, and hence it is transfer of whole interest. What is transferred is not merely right to use land. Building was constructed, so the lessee constructs the building on the land allotted by the lease by DIDC, and land along with building has been transferred. In other words, something which was constructed on the land is also transferred. This constitutes profit appendre, which is again immovable property and not liable to tax under GST. Black's Law Dictionary they bring in, saying assignment is transfer or making over to another the whole of property, real or personal, in possession or in action, or of any estate of right therein. The transfer by party of all its rights to some kind of property, usually intangible property, such as right in lease, mortgage, agreement of sale of property. All of this is assignment of rights. Then they say assignment of leasehold rights is not covered under 7(1) of GST Act. It is neither business for the assigner, nor it is in the course of furtherance of business. Transaction of assignment is sale simpliciter. It's transferring absolute rights in the land, and it has nothing to do with business of the transfer. Section 7(1) would not be applicable as dealing with immovable property is not covered under GST law, and supply of land in every form was excluded from the purview of GST Act. Then they talk about service. Service is anything other than absolute transfer of property. The attempt of the respondent to encompass transfer of property within service amounts to extending the meaning of the word service beyond reasonable connotation. And assignment of leasehold rights is absolute transfer, so it is not service. Whatever right the lessee has is the sale of interest in land, which is equivalent to sale of land. And it was therefore submitted that sale of leasehold rights cannot fall within the scope of supply of goods or services and is an absolute transfer, and therefore it is not service. Then they say legislature never intended to tax a sale of immovable property. Entry 18 of list 2. Land covers rights over and above land. Statement of objects and reasons for constitution amendment also says that it is subsuming other indirect taxes so as to reduce the cascading effect of the taxes. However, entries in list 1 and list 2 relating to stamp duty were left untouched. This shows GST was not intended to be imposed on any transfer of immovable property. They also bring about the agenda and the minutes of meeting of 5th and 7th GST Council meeting, which says that stamp duty had not been subsumed in the GST law. So the aspect of stamp duty is different. GST is on aspect of stamp duty is on immobile property. GST is on goods and services. Therefore, imposition of GST on land and building would lead to double taxation and might be and is also unconstitutional. Considering such objection, the GST Council decided to defer imposition of tax on land and building. So therefore, Schedule 3 excludes sale of land and sale of building. It was also submitted that this exclusion is nothing but manifestation of intention not to impose tax on transfer of immobile property, as was the case even under the erstwhile service tax regime. Therefore, they submit that proposed imposition of GST on assignment of leasehold rights leads to double taxation. They also say that exclusion of sale of land and building has to be interpreted in the light of the legislative history, as well as the objection purpose of the statutes and constitution. So it would cover sale of interest in land and benefits arising out of land also as under sale of land and building. Then they also submit that leasehold rights is a capital asset and it's a property. Since it is a capital asset, it is again not service. It cannot be service. It is again transfer of immobile property. This is similar to what we've been speaking so far. Land in the ordinary legal sense comprehends everything of a fixed or permanent nature, and therefore growing trees, land includes benefit arising out of land and things attached to earth permanently. Leasehold rights is nothing but benefits arising out of land, and as such, assignment of leasehold rights is nothing but transfer of immobile property, subject to stamp duty as well as registration. So just to summarize, what the petitioners are trying to say is the benefits arising out of land is immobile property. Transfer of leasehold rights is benefits arising out of land, and it is absolute transfer by the lessee to the third party. Absolute transfer by lessee or absolute transfer is akin to sale of immobile property. Sale of immobile property was never or intended to be taxed under the GST law. And so therefore, the transfer of leasehold rights is not liable to tax under GST. This is the overall gist that they are trying to say. They've also gotten the DLF case which says development rights is transfer of immobile property, since and leasehold rights is a greater right, and hence it's not liable to tax under GST. Any doubts so far, or should we move on to what the respondent has to say?
Proceed.
Please continue, madam.
Okay. Moving on. Right. So respondents or the revenue or the government, basically the people representing government or the Union of India, they are saying that meaning of immobile property should be understood in the context of the provisions of GST law and not in terms of other laws which are not parameteria to GST law. And they talk about, yes, immobile property is not specifically defined, but there are certain provisions of GST Act which talks about immobile property, such as 2119 works contract, 17(5) C and D, which talks about block credit for works contract, Section 12 of IGST Act and 13 of IGST Act, which talks about place of supply. And all of these talk about tangible immobile property. None of them talk about intangible immobile property, which is what is leasehold rights. And intangible rights in immobile property or interest in immobile property is liable to tax under GST law. And hence the definition of immobile property brought in through General Clauses Act, etc., will not be applicable for GST law. Leasehold rights with respect to immobile property is an interest in immobile property. It is an intangible asset, and it does not have any physical existence or identity as being commonly understood. When transfer of such leasehold rights take place, it would be nothing but transfer of interest in immobile property. Finance Act 94 also says interest in immobile property was not being considered as immobile property. So the service definition in the service tax law says transfer of title in immobile property is not service. So the respondents are presenting it as interest in immobile property was not considered as immobile property, even in the service tax law. Service is when one of the rights, that is right to occupy land, is transferred by GIDC in favor of the lessee. It is to be treated as supply of service under GST Act. It is further transfer, which is also transfer of right to occupy, possess. So firstly, the lease itself is service, and the further transfer of lease, that is the assignment of lease, is also transfer of rights to occupy, possess, and it will continue to be supply of service. And these characteristics will not change merely because the lessee of GIDC affects absolute transfer in favor of SSE, in the favor of the third party, leaving no rights whatsoever with the lessee. This is one of the important, this is one of the most important submissions by the respondents, saying the rights in the leasehold rights is basically just an interest in immobile property. It is not immobile property itself. And the transfer of such leasehold rights will remain to be supply of service, because lease is supply of service, and the characteristic will not change just because it is absolute transfer in favor of assigning. Interest in leasehold right would remain the same with the recipient, whether he gets the same supplied directly by GIDC in the form of leasehold arrangement or from the original lessee in the form of assignment. Interest in land would still be interest in land. It would not be sale of immobile property. There's a possible classifications for services: 9972 lease, 9983 advertisement space and space, or the rights in immobile property, which is like an advertisement space, etc., which is like rights in immobile property, and 9997 miscellaneous service. So they are saying these are the possible classification. They also bring in definition of service under Council of European Union, which says supply of service may consist inter alia the following transactions: assignment of intangible property, whether or not the subject of a document establishing title, obligation to refrain from an act, and performance of service in pursuance of an order made or in the name of public authority. So they are saying assignment of intangible property and obligation of immobile or refrain from an act is clearly service. So it is supply of service and it is liable to tax under GST. They bring in aspect theory. They say that Stamp Act and GST law, the aspect of tax or aspect of paying stamp duty is different from the aspect of tax under GST, and there is no double taxation, though there could be overlapping, similar to how manufacturing and sale was on so excise duty and let's say sale or tax on VAT were on the same similar where on the similar transaction, but the aspects were different. Excise duty was on manufacture, VAT was on sale. Here, the tax on stamp duty is on a different aspect. Although it could be that the stamp duty is on the conveyance or on the akin to the conveyance. However, it's on a separate transaction altogether. It's a separate aspect altogether. And the tax on GST is on a separate aspect, which is on supply of service. Stamp duty is paid on instrument of conveyance and GST is paid on supply of service. So there are two different aspects and hence there is no overlapping. And there is nothing in Constitution which says that from which one can spin out that there is a wise of double taxation. Then they say that lease is partial transfer, right of reversion remains with the lessor. Sale is absolute transfer and there is no reversion. Sale is absolute transfer. There is no reversion right on the owner. Once it is sold, it is sold. There is the complete rights, liabilities, risks are transferred to the buyer. In case of assignment of leasehold rights, it cannot be doubted that the land which was demised was merely an enjoyment of the land and not transfer of ownership. Exemption notification should be strictly interpreted. The exemption in the GST law applies only to government allotted leases and not to private transactions. Then Section 108 of Transfer of Property Act, which talks about rights and liabilities of the lessor. It says that the lessee may transfer absolutely or by way of mortgage or sublease the whole or any part of his interest in the property, and any transferee of such interest or part thereof may gain or part may again transfer it. So the transferee also can retransfer it, but the lessee shall not by any reason, only because of such transfer, cease to be subject to any liabilities attaching to the lease. So Transfer of Property Act says that all the rights can be transferred, but the liabilities pertaining to the lease still remains with the lessee. So the respondents are saying it is not absolute transfer, it is still transfer of interest based on Section 108. Any thoughts here? I will just overall summarize what is happening, what the respondents are telling. They are saying that immobile property definition cannot be borrowed from. Immobile property definition cannot be borrowed from other laws. GST doesn't, in GST, what is not liable to tax is sale of immobile property. Transfer of leasehold rights is not sale of immobile property. It is just transfer of interest in immobile property. And since it is transfer of interest, it is supply of service and liable to tax. This is what they're overall trying to say. And they're saying aspect of stamp duty cannot be a blocker in saying that it is not a supply of service. Stamp duty is on instrument of conveyance and tax on GST is on supply of service, and both of them, there is no double taxation because of both of these acts. Any thoughts or any discussion here? We'll move on to what the High Court is ultimately concluding.
Dhanashree, so the conclusion was on some principles. Maybe I would want to hear your views.
Yes.
Would this be applicable in all scenarios? Firstly, do you agree with this judgment, and would this hold waters when this is challenged by the union? And what should be advised to the customers? Because there could be situations where the lessee has given
Hello, Venu.
similar to the finance lease of AS 17, or out of the balance period, he is, let's say 30 years is left, he is giving for 29 years. Last 1 year he is keeping anything of some alterations happening to the contract, not exactly what GACDC case, then would the argument would still be hold good that it is an immovable property, considering respective state is levying the stamp duty, saying that this transfer as the stamp duty, because that's a stamp duty is a state subject, and however they choose, they can do it.
Sure, I will touch upon that once I talk about what the court has to say.
Dhanashree,
Yes,
when
sir.
you're addressing that, you have shared with us now what both sides have argued.
Yes, sir.
Both sides have argued, especially the petitioners have argued everything under the sun. So the reader of this law may tend to assume that all those are true and reasonable arguments. From your study, can you tell how much of that is bullshit that the petitioners have thrown at the court, so that as students of this law, we don't buy into that rubbish that they have said? You would have studied it and distilled what is reasonable, what is unreasonable, because every sentence in the judgment will be taken out of context and quoted as if that is the law laid down. Before we go into the actual, what did the court eventually say? You have now shared both sides. What is your assessment of the arguments? What is reliable? What is completely rubbish that people have said?
Right, sir. I'll just open the judgment. So some of the things, like Jatin sir rightly said, the petitioners have just taken everything, argued everything under the sun, and they've said that, okay, this is what it is. For example, they've said that one is they've said, okay, first of all, we are not liable to GST. If we are liable to GST, give us input tax credit. That is one of the things that they've said. If we are liable to pay tax, you allow us input tax credit from the beginning, whenever we are liable to say. That is something that I don't agree with what petitioners are saying. Then in terms of
Madam, can you display the PPT? We can discuss one point each. Arguments for
arguments of the petitioner.
Dhanashree, I also have some small doubt, basic doubt, I would say.
Yes, Sujata.
See, forget about GST, forget about income tax. I'm just coming from the basic fundamentals, okay? When assignment is not defined in the Transfer of Property Act, will it not be a contractual obligation? When it is a contractual obligation, let us come to the valuation later. In my view, valuation means it should be the differential. How we do for capital gains, sale minus purchase values, the differential. On that, there can be a capital gain. If you say that it is a supply of service. So I am not able to agree to the view that it is a all rights are transferred. So it is a conveyance and it is a sale under immobile property. I mean, it's being an immobile property. So I don't subscribe to that view. My only question is that when transfer of property does not define the assignment, specifically the assignment, will it not come under the Contract Act? Is it not a contractual obligation?
If I'm understanding your question right, you're saying if assignment is coming under Contract Act, and since it is the contract
between the lessee and the third party, So how are we saying that there is no supply of service?
Okay. Okay. So the petitioners, what they are arguing is it is transfer of absolute rights. They are not reading section 108 of Transfer of Property Act, which says that the liability still persists with the lessee. And since they are saying it is absolute transfer of right, and that's why it is not liable to tax under GST. That's what they are saying, which is what the respondents are saying. No, 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 it is just an interest. And since it is an interest in immobile property, it is not absolute transfer. Section 108 of Transfer of Property Act also does not ultimately transfer all the liabilities of the lessee to the third party. The liability still persists with the lessee, and hence it is not absolute transfer. This is, I think this is the deadlock where one is saying it is immobile property and it is absolute transfer of immobile property. And the other is saying, no, it is not absolute transfer of immobile property. It is just interest in immobile property. So both these views, the view of the petitioner, which talks about absolute transfer of immobile property, also is sort of coming through from the DLF case law, which says development right is also absolute transfer of immobile property. Lease rights is greater than development rights. So this question, whether it is really absolute transfer, I think that is what is really questionable, because it is not sale. What is not liable to tax under GST is absolute transfer or the sale. And since it is not absolute transfer, it can be questioned. However, the other thought which the respondents are also putting, which the court is agreeing to, is that immobile property is a bundle of rights, and one of the rights is leasehold rights. The court is agreeing that the first limb of the transaction, that is the lease, GIDC to the lessee, the lease is supply of service. It is exempt, but the second limb is absolute transfer by the lessee to the third party. And this absolute transfer, benefit to arise out of land, is immobile property, and absolute transfer of immobile property, it is saying, is outside of this one. However, if we really look at what the GST Act is saying, what Schedule 3 is saying is sale of land and sale of building. It's not talking about absolute transfer of immobile property or generally any immobile property. It is just saying sale of land and sale of building. And sale means sale and nothing but like sale. Like basically, sale is, there is no reversion, there is no liability on the person who is transferring the rights once the sale is complete, once the sale is executed. And this is where the court is saying that no, it is whatever the lessee is transferring is absolute rights, and that is where it is not liable to GST.
Madam, can you just project the PPT?
From here?
Yes, yes.
Here also they're saying that the assignment conveys whole interest without a reversion.
See, let's see, is this a false statement they have made or not? Why are you simply admiring the problem here? Have they lied through their teeth to the court?
Without a reversal,
What's the hesitation to call a spade a spade? At least Tuesday morning, no one's watching us. If it's wrong, let's call it wrong. No, why are you hesitant?
yeah, I agree that it cannot be whole interest, because in assignment, the person who is assigning still is liable for whatever is his liability. Though the rights are all transferred, the liability still is with the assigner.
Dhanashree, I will take your car. You'll give me your car to use it for one weekend. Monday, you come and ask me for the car. I will tell you I sold it off. Possible, not possible.
You
You
cannot.
gave me your car to use it for the weekend. Monday, you came and asked me, where is my car? I said, sorry, I sold it off. Possible, not possible. You go ask the buyer if he will give it back to you.
So you cannot sell or you cannot give what you don't have.
Therefore,
That
how can the second transaction between lessee and assignee be greater than the first transaction between the lessor and the lessee? That's all
Yes.
is the conclusion.
Yes. So the court is also talking about it. I agree with you, sir, that what the lessee does not have, it cannot give.
Then
Like
why
the
did they
lessee
render the
doesn't have
judgment like that?
absolute ownership. Sorry, sir.
Then why did they render the judgment like? We haven't come to that part. You're going to take us through that part shortly. If the court appreciated all this, what did
Yes.
they finally do? Isn't it?
Yes. Yes. So
Having
actually,
appreciated
will we go
everything,
through that, sir?
please. No, but your summarization of the arguments of both, because you presented many things, the Mailar is totally confused. He wants to do a page turn. He wants to sit and argue page by page. Give your conclusion of what petitioner bullshitted here and what respondent said about it.
Madam, if you read through the judgment, definitely it is not a good law. The other thing is, see what has happened, it is more like a street fight. The counsels of the petitioners, they knew very well what their arguments are not correct. But still they tried in such a manner that, okay, let us take a chance. We'll see what happens. And obviously, it's like, between two parties, respondents as well as the petitioners. So, okay, it's only a matter of chance that, this time the petitioners have won. But, madam, if you see, there are two legs of transaction. You started off saying there are two legs of transaction. One leg, they say it is not taxable. One leg, they say, from GIDC to the lessee, they say it is a supply of service. And invariably, most of it are more than 30 years. They looked into notification 12, I think entry 41 or whatever. So they said, okay, it is exempt. So obviously not liable to tax. There, they did not discuss anything on the Transfer of Property Act. They did not discuss on the Registration Act. They did not discuss on the General Clauses Act. When it comes to the second leg of the transaction, there is a slight difference in the second leg of transaction. The lessee, see, when GIDC came to the lessee, it is only the plots, developed plots with roads, lighting, drainages, etc., etc. When lessee gave it to a third party, in some cases, the lessees have built some superstructure, maybe a shed, maybe a factory. So those things also happen. The second leg, they say it is akin to transfer of immovable property, whereas the first leg, they say it is supply of service. I think this is where somewhere, I'm sure the union government, the central government or the state, they will definitely file an SLP. I don't know as of now, I have no information whether they filed or not. But as we see, government, even though a little delay, they will file. But madam, in my personal opinion, this is not a good law. Maybe till the Supreme Court set this as, because this is a division bench judgment. So obviously SLP has to be filed before the Honorable Supreme Court. So till that thing happens, a lot of lawyers, a lot of cases, people will keep arguing. But I think as students of law, I don't think this is a good judgment. Somehow the judges have got swayed by the arguments of the petitioners, and petitioners have won the battle because the councils knew very well that they were, what they were arguing was all rubbish. And they knew, yes, we are paid the fees, we need to do something for the petitioner. That's what I mean, this is my personal assessment of going through this whole judgment.
So
Right. So
presentation completed, huh? Now.
the another
Madam.
thing which I wanted to highlight was what happens to, like Vijay sir pointed out, saying the lessee is giving the right, it's transferring the leasehold rights on the land, and it is building certain buildings, etc. And then it is transferring those rights as well. What happens at the end of the lease? What happens after 90 years, 99 years, whatever it is? What happens once the third party comes back?
Madam, as I know this judgment, the second leg of transaction was invariably a tripartite arrangement. That means you will have GIDC signing the agreement, you will have the lessee, you will also have the third party. So eventually, end of the period, whatever, if you go through the text of the agreement, generally it says it should come back to the government. But because of the other allied laws, more than 30 years, it is almost considered as, you have given up your rights. So that is how they go. But if you really go into the text of it, the title, the legal owner will always be GIDC. It is akin to KIDB in Karnataka. So it will be something similar. I don't see any difference.
So actually, let me just go through what the court is saying. And then I have a couple of points to add, which the court has touched upon and not gone in detail, which we all can sort of discuss and then come to a conclusion. So the court says there are two transactions. The first transaction, as we all know, the court has agreed that the transfer of a lease, transfer of plot of land on lease is liable to tax. However, notification 12, entry 41 is exempts it. Exemption for one-time upfront amount payable in respect of the service by way of granting of long-term lease of industrial plots. Here, my question actually is, which I want to understand practically, because in lease, there are two considerations. One is the premium or the salami, etc. Second is the periodical payment, which is rent. So does the lessee pay any periodical rent to GIDC? And what happens to that? That is a practical question that I have. I don't have the answer to it. I'm opening up to everybody, which we'll discuss about it. The second bit they say is the transaction of sale and transfer of leasehold rights by the assigner in favor of assignee divests the assigner of all the rights, and therefore the interest in the immovable property in form of leasehold rights cannot be said to be different from immovable property. And taxing statute is to be strictly construed. The subject is not to be taxed without clear words for that purpose. And also every act of parliament must be read in accordance with the natural construction of its words. So they say that supply has 8 forms of supply: sale, lease, license, disposal, etc. All these 8 forms of supplies, and only these 8 forms of supplies. Transfer of leasehold rights or the assignment of leasehold rights is not covered as a part of supply, and hence it is not liable to tax. Again, they talk about assignment being absolute transfer, and they're saying as per the provisions of Stamp Act, instrument of lease is considered at par with conveyance for lease. And they've gone by what the petitioners are saying, that because the Stamp Act is, because stamp charges are levied by Stamp Act on the instrument of lease or the instrument of assignment, it is considered to be immovable property and not liable to tax. So this one, like I said, in service, they are also getting, in service tax era, there was no intention of the legislature to impose tax on transfer of immovable property. Development rights, which are benefits arising from lands, were not liable to tax in service tax era. And lease is greater rights and interest in land, and hence it is not liable to tax. Even in GST, levy of GST on construction service are exclusive of 1/3 of total. So again, land is never taxed under GST, is what they're trying to bring here. So overall, they're saying that it is absolute transfer. Though they're saying that nemo that quod non habet, no one can transfer a better title than what he himself has. Considering the nature of transaction, when lessor assigner transfers the entire leasehold rights along with building to the lessee, it would amount to transfer or assignment of all the rights of immovable property by the lessor, and hence it is not liable to tax. All this 9972 or 9983, etc., is not applicable, since it is land and building appurtenant to land, and it is transfer of immovable property. So, in my view, now let me talk about what my thoughts are overall. So I agree that the petitioner is lying through teeth. They are saying that it is absolute transfer. I do not agree that it is absolute transfer. I'm with Jatin sir on that. The petitioner cannot transfer more than what he himself holds. If the petitioner does not have the right or does not have the right to absolute transfer, the lessee cannot do absolute transfer to the third party. So I'm agreeing with that as well. Stamp duty and GST are on two different aspects. Just because stamp duty is applicable on the instrument of conveyance of the assignment does not mean that GST is not applicable on that, because GST is on service. So stamp duty and GST cannot be put together and read in same light. However, what the court has ruled, it says that supply is to be read strictly. I want to sort of think a little more about that. Supply includes these 8 forms of supply: sale, transfer, lease. Sorry, what are the other forms?
Barter, exchange.
Barter, exchange, disposal. All of these are the 8 forms of supply, and supply does not go beyond these 8 forms. Assignment of leasehold rights is not defined as supply, is not included in the definition of supply, or not included in one of the forms of supply. So I want to give it a little thought and open it up to all of the members, saying, is assignment a separate form of supply, or can it be included as transfer?
Yeah, it gets covered under transfer in my view.
Now, moreover, Dhanashree, is it a exclusive definition because they use the word such as? So it should include.
So we have discussed this multiple times in our study group itself. Though supply says includes, it is still exclusive. There are these 8 forms of supply, and that's about it. There is no other form of supply which is not included in the supply, which becomes a supply.
1 minute. Annapurna and Mylar. We start with Mylar first. Yes, Mylar, do you think rule of ejusdem generis is applicable in section 7(1)(a)? What is your study of rule of ejusdem generis? What is your study of rule of ejusdem generis? When it will apply, when it will not apply? Tell me. Mylar, log out.
Illa sir, ideni sir.
What is, when will rule of ejusdem generis apply?
So whenever the word, general word like etc. and other things which is taken, followed by a specific set of group of words, then that word will take the characteristic of the thing which is followed from the previous words.
Very good. Now we will see whether there is any general words at the end of the list of 8 words. Is there any general word at the end?
No.
Then why you are saying ejusdem generis will apply? There is something like a general word at the beginning, but that is not what you said for the application of rule of ejusdem generis. The general word should be at the end and not anywhere else. Agreed?
That is agreed, sir. But
okay. So 1 minute. So therefore, ejusdem generis will not apply. Now you proceed.
Yeah. But it says all forms of supply, such as. So they are giving only example of some of the thing and not everything is they are covered in that definition.
I'll give an example. Is sublease covered?
Yes.
In the 8 forms, is sublease covered?
No, specifically
covered.
not sublet. Huh.
But sublease is something equal to or less than lease. Therefore, sublease is also covered. Correct?
Correct.
Is works contract covered? Works contract is not covered, but works contract is covered as transfer of property in goods. You understand? So therefore, it is equal to or less than transfer. So therefore, such as is not to create a 9th form of supply, such as is only to cover all the subspecies of the superspecies in these 8 forms.
Okay.
You should read, there are some 2-3 judgments. Supreme Court in one judgment said, "Ejus dem generis should be used." Then later in another judgment, they said, "We made a mistake last time. You should not use ejus dem generis to interpret this language." This is discussed in GP Singh. All right. So now can you summarize what we have learned today morning? Is ejus dem generis to be used while reading 7.1a or it is not to be used?
Not to be used.
Finished. Annapurna madam, ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ರಿ madam? It is a transfer. Please tell me. Explain yourself. What is a transfer?
Sir, transfer can be absolute transfer. Transfer can be rights or interest also can get covered under the transfer. Sir.
In which context you made this statement, madam?
Sir, in assignment of leasehold rights,
I'll give understood. I'll give you example. As chartered accountants, we all understand what is transfer of shares. Yes.
yes, sir.
As chartered accountants, we all understand what is transmission of shares.
Yes, sir.
Is transmission a transfer?
No, sir.
Therefore, everything that brings about in substance a vesting of title in another person does not have to be force fitted into the term transfer. Upon death of a shareholder, the shares go to the successor in interest. It is like a transfer, but it is not a transfer. Why is it not a transfer? There is no ingredient of willing consent of the transferor who died. Everything that results in passage of title, we should not force it into supply. Another example I will give you. Suppose somebody takes a term loan on machinery, defaults on the term loan, the bank will come and take over the machinery. Is it a transfer? No, because ingredients of a transfer are absent. By operation of law, title passes.
Right.
So
sir.
therefore, there are many transactions that behave like a transfer according to common sense, but legally cannot be forcibly fit into the 8 forms of supply. Keeping in mind that Mylar helped us conclude that ejus dem generis cannot be used while reading 7.1a.
Sir, my doubt here is, should transfer be done only by owner, like when only by holder of legal transfer title can only transfer, or like can transfer be used more widely?
Section 5 of Transfer of Property Act very categorically says what are the ingredients to bring about a transfer. Section 6 talks about what transfers are prohibited. How can we leave this entire body of knowledge in transfer of property law and introduce our logical sense of what is transfer, what is not transfer? Insurance company, when they settle the claim, the wreckage belongs to the insurance company. Is it a transfer? No, but can insurance company validly sell the scrap? Yes. If the legislature wanted to cover everything, they would have drafted this law differently. When we are supposed to only interpret the law, we are attempting to legislate here. All right. So now we've come back to the question that has been bothering us. Is assignment a transfer?
Cannot be also because the lessee does not have absolute title. So it cannot be transfer.
It is merely a transfer of leasing rights and not the ownership.
Well, we'll come to the transfer of leasing rights. We will come to Mylar. Mylar, Annapurna, you have to comment whether assignment therefore fits in the definition of supply.
Sir, I had thought that this gets covered under transfer and hence fits. Now I'll have to read thoroughly. And
Okay. Background material odila. Mylar.
Sir. Yeah, I don't think it is covered.
Okay. Again, I'm sort of talking too much. Venu told me not to talk too much. But madam, you continue, Madi.
Sir, this is your topic only, sir, actually. But in my view, assignment would become like the 8th form of supply, which is not included in the definition of supply, and because of which it would get out. Not because it is absolute transfer. All of those arguments don't stand true in my view. But if it is not one of the forms of supply, it would get out is my view, sir.
Okay, so then now you can go to the third part of your presentation. What finally this damn court said, you please help us understand.
So the court has concluded that it is absolute transfer, though it touches upon nemo dat quod non habet. Nobody can confer a better title than what he himself has. It says, considering the nature of transaction, I'll just project my screen also. It says, considering the nature of transaction, when lesser assigner transfers the entire leasehold rights along with building constructed thereon to the assignee, it would amount to assignment of all rights in the immobile property by the lesser assigner. And since it would amount to transfer of all rights, it's absolute transfer and it would not be subject to levy of GST. It says it is an immobile property itself and not an intangible property, as leasehold rights transferred by lessee or assignee is with the concurrence of JIDC. The facts, therefore, the transfer charge. So basically, they're saying the transfer charges paid by the lessee to JIDC would be leviable to GST, but not the assignment itself. It would amount to absolute transfer of immobile property and hence it would not be covered under GST. So I don't agree with the logic that the court has applied to conclude. But somewhere in the passing, the court has mentioned that taxing statute has to be considered strictly. Taxing statute is to be considered strictly. This is where I'm thinking about a bit, but as such, the way the court has concluded that it is not liable to GST because it is absolute transfer, I don't agree with that.
All right, I think now we have to reflect on Vijay sir's comments. Actually, Vijay sir, why don't you give your summarization once again, please? help all of us.
Sir, as I said earlier, somehow this is not a good law. When the first leg, they consider it to be a supply. According to me, even the second leg should be considered as a supply. But somehow they got swayed by the arguments of the petitioner's counsel. And somewhere when you read through the judgment, sir, even the petitioner's counsel also knew very well that what they were arguing was not right, but they just took a chance. So according to me, definitely it will go before the Honorable Supreme Court only. It's on SLP filed. Both the cases are supply only, sir. The first leg and the second leg also. Once it's a supply, then we need to examine. If it's a supply, then where it falls, Section 7, notification, etc., etc. I think that is where it has not come out properly. So, I mean, this is what I feel. And I don't think we as students of law should rely on this judgment. I don't think, because we start relying on this judgment, then we are doing something which is not correct. Our entire understanding of GST law will fail. Because the whole concept, even Schedule 3 talks about sale simpliciter of land and building, not the interest in any of them. Of course, there's a clause beyond 30 years, there's exemption. Okay, those things you can take the benefit, but this, when they say it is not a supply per se at all, I think there is something wrong in this judgment. So this is
That they're
what
saying
I could
because,
gather, but somehow I didn't.
yes, sir, go ahead, sir.
I didn't enjoy reading the judgment. Somehow the judges got swayed. That is very, very clearly coming out. They forgot completely the first leg and the second leg are more or less will be on par, but somehow forgot the first leg. They themselves say it's a supply. Second leg of the transaction, this is not a supply. So I think that is where things have gone wrong in my.
And I think the height of faults in the judgment is clearly there in para 83. Para 83, which says clause 5 of Schedule 3 is not applicable to this case. And because clause 5 of Schedule 3 itself, they have taken the shelter to say that it is not a supply because it is a part of Schedule 3. There itself they have done such a mistake. Even Schedule 2, para 5b they referred instead of 5a. 5b is all about works contract, and 5a is about lease, where they said leasing. This is not even a lease. So even the definition of sale of land, according to Section 54 of TP Act, is completely ignored, which defines what is sale of land. Unless it's a sale of land, and then it falls under clause 5 of Schedule 3. There is no reason why they should say it is not a supply at all. So I felt uncomfortable reading this judgment. I don't know whether it was worthwhile discussing in this forum this judgment. My personal view is it was a defective judgment, lot of mistakes, and only the one point, absolute transfer. I think this expression was, it was thrown on the judges very often. And the second term they used is the lessee is completely coming out of the arrangement, coming out of this transaction completely. And there is absolute transfer. But what is absolute transfer? It is not the transfer of ownership. Absolute transfer is of the leasehold rights and not the ownership, as which is an important ingredient required to establish that it is a sale of land. So I think not a good judgment. Is definitely requires course correction in future.
I have another question to the forum. Like, if this is appealed to the Supreme Court, and let's say Supreme Court passes an adverse order, then what happens to the High Court judgment? Does it serve any purpose, or it is fully null and void? None of the sentences make sense. What happens?
According to my limited understanding, madam, in case SLP is filed and the Supreme Court admits the appeal and it grants stay, this judgment will not hold the water. People cannot, use this as a precedent until the matter is adjudicated and decided by Supreme Court.
Dhanashree, in this agreement, the facts of the case, is it anywhere different from traditional conventional assignment deed, or is it different in this case?
What are the facts of traditional?
Like, they assume, whenever there is a assignment is given, of course, in this case, they are taking the consent of the lesser, correct?
Hmm.
For transfer. So is it like any other PIDs, like how we have in Karnataka, same way, or is the facts are different for this particular case? Whenever I give some leasing right, there will be some set of conditions that you cannot assign, you cannot do this, you cannot sell. There will be some conditions.
Yeah, even in this,
Right.
madam, GIDC need to allow, permit for
Correct. So
this.
they have permitted, perfectly fine. So is there anywhere different from this particular case? Is it different from traditional assignment deed or lease deed, or is it different? Is it the same or is it different? Facts are the same, just like any other assignment deed, or is there anything different in this particular case?
Actually, in the judgment, we see that, there is also a licensing arrangement followed by, once the conditions of that licensing arrangement is fulfilled, then this lease agreement will come to play. Something like that is there in the judgment. So I think that is because the lessees are getting the permission to construct the building and then assign rights in that as well. I mean, I don't know, like.
So one more thing wanted to highlight in the judgment, which is also they are discussing Noida Authority case, and they're saying what happens to that building. So like Annapurna was saying, the GIDC gives a license to the lessor to build whatever building and things like that, and then also gives permission to assign the entire thing. So what happens at the end of the assignment? What happens to the building? So the building also becomes part of the rights of GIDC, or it has to be completely demolished and given, and the land be given back to GIDC on as is basis. That's what that Noida Authority case says. So ultimately, GIDC is the owner of the land and land appurtenant, whatever is happening on the land, is what I understand. So nowhere the lessee is the owner of the building just because the lessee is building the building.
Yeah, he can demolish or he can leave as it is and hand over the
Yeah.
property back to GIDC at the end of 99 years. GIDC is only interested in the land.
Madam, practically what happened, this all is done to encourage industries. So practically how it works is, even though they mention 99 years and all, there'll be a clause, it will get further extended. So it's something like almost like for perpetuity, whoever is a lessee, he'll continue to hold it. This is all theoretical, saying that after 99 years, he'll demolish, he'll give it back. Generally, it doesn't work that way. Across the country, this is how things work. Earlier, municipalities were giving for 30-year lease, 99-year lease and all. And generally, we have seen getting extended. Nowadays, municipalities are taking back. But this KDB or GIDC or Maharashtra MIDC, it generally continues. There'll be a clause after 99 years, it'll further continue, or as is various basis, they'll put up for auction. Something like that will happen.
Got it.
Jatin sir, a question on this actually. Sir, if we refer this erstwhile law decisions or erstwhile law, we have seen that this assignment of leasehold right was never taxable as such. So what is the difference now in GST law where we are trying to put it because only it is covered under the scope of supply, and we are trying to say that it is leviable or within the meaning of definition of service because it is very wider as it is covering other than goods. So we are trying to bring out that kind of right and trying to say that it is leviable. Because definitely the arguments are not only on the leasehold rights, there are various other rights which are attached to the land. And still the dispute is continued on this transfer of rights with the land. So somewhere we have to look into that perspective also, no, sir? Because is it only we are saying it as a supply of service, or is it we are trying to say that rights which are attached to the lands are liable to GST? Because again, there is if you read the third schedule, it is using the term as sale of land, whereas we are able to trying to interpret the petitioner has tried to interpret from the definition of immovable property, which is very wider than the scope of land. So somewhere we are just trying to understand from the. I agree with the decision is not correct. All that is fine, sir. But just trying to read from the GST perspective and trying to differentiate from the erstwhile decision. Like anyway, they have relied on that decision and the other decision. But somewhere I'm not able to take up the analyzing from that aspect also, sir.
See, in 65B44 of Finance Act,
Yeah.
transfer of immovable property was excluded from the definition of service.
Yes,
So
sir.
therefore, judgments from service tax are only talking about the universe of immovable properties that are transferred to be kept outside the definition of service. In our
Yes.
mind, we equate immovable property with land or building. If we understand that, let us take all the stars in the sky in the night. All the entire night sky is immovable property. One planet is land, one planet is building. Now
Yes.
you please imagine in your mind, when we say all immovable property is outside GST by Schedule 3. Schedule 3 is saying only two things, this star and that star. Now we have to answer, what about the other stars in the night sky? That is first point. So therefore, all the service tax judgments, etc., we should be very, very careful before allowing fertilization of GST interpretation by judgments from service tax. Secondly, when we refer to immovable property, we are referring it to the thing, the land or the building. Property is not the thing. Property refers to the rights over that thing. You understand?
Okay.
So the right is different from the thing. Now, what is being transferred is the right and not the thing. The right is transferred, as a result of which the thing can be enjoyed.
Okay.
The lessee, the lessor has, like Dhanasri was saying, a bundle of rights, the full night sky, because it is absolute title. GADC has absolute title. Out of all the stars, they are taking one star and giving it to the lessee. What is that star? The user of the demise. You can use it. They never even allowed the lessee to retransfer. To retransfer, another star should have been given. So the lease agreement should not only have been the right to use the land, but also the right to give away the right to somebody else. You understand? So therefore, we use terms like sublease, assignment, etc. very lightly. So the last point to mention here is the way in which certain transfers have to be made, have to be examined not based on the name of the document, but on the rights that flow from that document. The lessee of industrial land was given the right to use the land for 99 years. He was never given the right to re-give that right to somebody else. And if now he gets the right to give away the right to somebody else, then this second right should come from a new contract and not merely NOC from GIDC. Because the new contract requires new consideration for it.
Okay.
If there is no new consideration to get this right, then it is not a valid transfer to the lessee. Therefore, it cannot be a further valid transfer to the sublessee.
Okay. Okay.
If somebody, suppose now V.S. Date sir has written a book on GST. Now Date sir has the, taxman has the copyright to that book.
Hmm.
Now if some other publisher, Bharat Publishing, wants to take that book and publish it, they have to take that right from taxman. We have to
Yes.
see whether taxman had the right to give it away or taxman had only the right to keep the product.
Hmm.
If suppose they had all, now how will Date sir give his rights to taxman? He will not give the right to the to publish. He will give the full absolute copyright. The name of permanently vesting copyright with taxman is called assignment. Because you cannot take, see, when you transfer, when you call a document a transfer, then after the transfer, that thing must not remain in the original owner. When A sells a mobile phone to B will get the mobile phone and A will be left without a mobile phone. But Date sir brain has all the material in it. You cannot, it is not possible to remove that knowledge from his brain. You understand? So
Yes, sir.
therefore, what can be given is maximum a restriction on Date sir using that knowledge again in the same words. He can conduct a seminar and teach whatever he has written in the book, but he is in different words. But he will not be allowed to quote those words again in a printed form. When an architect does a drawing of your house, which you want to construct, there is no copyright for the architect in that drawing. Because copyrights arise only when it is made into a 3D model. That is why architects create a 3D model, keep it in the lobby, it will accumulate a lot of dust and will become ugly. They create it, later they may keep it in the storeroom and it may get destroyed also, but copyright exists. Therefore, we should be very careful not to be swayed by the title of the document, but look at the rights that flow via the document. The rights that flow must be rights that already exist under a valid contract, which can then flow to the next person. Last point is, if you buy PVR cinema ticket and you are not able to attend and you give it to me to attend, you are not an exhibitor of the film, so you cannot sell the ticket to me. You can only allow me as your nominee to enjoy the benefits which was yours to enjoy.
And
If you
we
take
have
the
seen.
1950
Yes. Yes, sir.
So what you are giving is benefits of an executed contract. Because I don't have to pay anything more to get this. Everything has been fully paid by you. So therefore,
One second.
who wants to talk?
No, sir. 1 second. It was just disturbing. 1 second.
All right. So
Yeah, I'm muted.
visualize it from that point of view, what rights are flowing and whether those rights existed in any person for them to flow under this contract. If we were able to visualize it, then the answers become quite straightforward.
Yeah, sir. And one more thing, we have seen that many times when the flats are under construction and there will be a transfer of, there will be an assignment of rights by transferring the flat A to flat B. Like, so even in that case also there is a transfer of rights from one person, but it is transferred from the builder and not from that flat owner.
See, because agreement holder has no interest in the property. This is said in section 54 proviso itself.
Yes.
But
So we
people
can
still
apply.
say, I have a right to execute sale deed. That right I am selling. That right, you get, right of specific performance is a non-transferable right. Section
Yes.
6.
Yes. Yes. Got it. Thank you, sir.
Sir, in this case, like there is licensing arrangement, there is this lease arrangement as well. Again, for lease, there are two considerations. One is premium and another one is rent. So premium is basically for the right. Rent is basically for the periodic usage. Is it that way, sir?
It all depends on what the document says. The transfer of the right is complete on payment of premium. The rental is for the cost of maintenance related to the property. Many times lease may take place without a monthly rental also.
Oh, okay, sir.
Yes, there's no compulsion that it has to be.
So, for this licensing arrangement, there was no other consideration, sir.
See, there's no. See, if it is a lease, license is what? Permission to use. Then I have got the possession itself. License is only an inferior right to possession. They are using these words. Be very careful.
But there is a licensing arrangement, sir, in this case, or
No, I have not seen the document.
oh.
How can there be a license after lease has been transferred?
No, because what they get is land, right to use land, no, sir. But again, they're constructing the building. For that, do they need the license?
No. See, the lessee is free to. Just 1 second. The lessee is free to do whatever he wants to enjoy his lease rights carefully, effectively, isn't it? So he can construct something that he wants as long as at the end of the term, he restores the land in the original condition. It is permitted.
So it is part of the leasehold rights itself. There is no special right required for the construction.
Correct. Suppose somebody takes a house on rent, they can enjoy it. They don't have to keep on paying extra money for cooking food there, for watching TV there, for sleeping there, for playing there. They can paint the house.
Yeah.
As long as they don't alter the title to the property, they're permitted to do. 108 talks about various rights and obligations.
Sir, under lease and sublease are interchangeably used, sir, or both are different, sir?
Both are different. Now we stick to this judgment. Finally, the conclusion, madam.
Yes, sir.
Finally, conclusion ಏನಾಯ್ತು madam ಇದರಲ್ಲಿ?
Finally, the court has concluded that it is not taxable. But basis
what
of our
is it?
discussion, yeah.
Yes. Really, please.
Basis of our discussion, the rights given by the lessee to the third party is the benefit to whatever he has got. It's not beyond, it cannot be beyond what he has. So it is again interest in immobile property. It is akin to lease and it is liable to tax.
So बाप से बढ़कर बच्चा नहीं है. But the interesting thing, it's not that we should not read. We should read bad judgments more than reading good judgments, or as much as reading good judgments. Look at what happened in this case. Show cause notices were given to various taxpayers. All show cause notices were quashed. Department filed another application to stay the operation of this judgment until a review is filed. The division bench even quashed the stay application, which means the show cause notices came to be finally quashed. Okay, now we'll see what happens. If, let's say, state goes to Supreme Court in 6 months, 1 year. Again, like Safari retreats, 2-3 years, it will keep dangling. And tomorrow it is going to be announced. Day after tomorrow, it's going to be announced. We will keep getting LinkedIn messages regularly for another 2-3 years. Finally, some judgment will come saying that, no, you can't do such things, etc. What happens to the show cause notices? Will those show cause notices come back to life?
Can't, no, sir, because the period is gone. Limitation.
So how they will get? Sorry. Somebody wants to say.
Sir, for counting the period that needs to be excluded, no, sir, 75.
Correct. Now it will go under SLP for declaration of law. Now, two ways it can happen. If it goes to Supreme Court and Supreme Court quashes this judgment, it is having one effect. Or if Supreme Court declares the law, saying that this is how the interpretation should be done, and send the matter back to High Court for, like in income taxes, to pass the order giving effect. If they do that, then it will have a different effect. Where was the need for division bench not to stay the operation of this judgment? Pending review of this decision as per law. Why was High Court so categoric in quashing the notices? Anybody, student of the law? Eli, please. Sujata, madam.
No, sir.
No. See, look at the story behind the story. Now that the notices have been quashed, no further recovery action. Any recovery made, they'll push for refund. And limitation will be in operation. 17, 18, 18, 19, 19, 20 over. Any notices under 74 will be read as 73. Those demands also will be truncated. Whatever Supreme Court tomorrow says, it will say Supreme Court may declare the law in 2 years, 5 years, 12 years. We've seen what happened in Mada versus Steel versus Sale. Can you see the litigation strategy at work here? Clearly, the taxpayer was wrong. They did not foresee that on these assignments, they have to pay tax. So they went hammer and tongs after the court, throwing everything at the court to somehow get the notices quashed. To somehow get the notices quashed. Now, sufficient ground is created that it is not 74, it is 73. See, even if Supreme Court overturns this judgment, the battle may be lost, but the war will be won. So therefore, this is also something to keep in mind. Are we able to put together an approach as to what needs to be done? It may not be in this scale. All the big legal brains are involved behind this. But if you see, many times we say, what we say is all bullshit arguments. It's not that people don't know it's bullshitting. Just do it very forcefully. It sometimes has persuasive power. Going back to our understanding of first principles, we have to see, therefore, what is our learning from this? Whether if we start quoting this judgment everywhere and say that, therefore, there is this judgment, hence assignments will not be liable to tax, etc. We will have given, that's what I think Venu's point was, how do we now go back and give advice to our clients about transactions? If the agreement is called sublease, what we should do? If the agreement is called assignment, what we should do? Maybe Dhanashree, you can conclude on those.
Sir, before going into that, a few high courts have also relied on this and they have remanded back to the adjudicating authority. How it holds good, sir? Like, how can the
remand with to reconsider is no declaration of law. They're only saying, please read this. Your decision rendered without considering this judgment is sub silentio. So please consider it and render it. We will see later. Anyway, matters will be in call book if it goes to Supreme Court, etc.
Yeah. Yes.
So, in my view, how do we put across, how do we consult our clients if there's somebody who comes with this? We definitely talk about saying this is what is the law, this is an interest in immobile property and it is liable to tax. However, there is this law. So if there is input tax credit, I would say go ahead, pay tax, claim input tax credit. If there is,
We'll come back to conclude on input tax credit, we'll come back to, but you please proceed.
but if there is no sufficient input tax credit in such a case, then hold not to pay tax, write letters to the department.
Papa, you're doing all this central excise advisory you're giving ma, yenama ಮಾಡ್ತೀರಿ ನೀವು GST ಮಾಡಿ ಯಾಕೆ central excise ಮಾಡ್ತಿದ್ದೀರಾ? Write letter, love letter, leave letter, ಇದೆಲ್ಲ it's all dead and gone. It's all, I don't know who you learned this from. Please abandon writing letters. Under what section an officer will receive your letter, you tell me? ಅಯ್ಯೋ ದಯವಿಟ್ಟು ಲೆಟರ್ ಗಿಟರ್ ಬರಿಬೇಡಮ್ಮ. No letters, no love letter, no leave letter.
So then, till the High Court case law is not struck down, especially in specific such instances that transfer of industrial right, lease right to the lessee and then assignment. In such a case, I would still go ahead saying there is High Court case law, but I would warn the client saying, see, it could be overturned, but there is High Court case law. But in all the other assignments, I would definitely say go ahead, pay tax.
Is input credit admissible on this?
17(5)(d) barred.
D works contract. C. Nodi.
C.
D.
C.
D.
C.
Nodi. Dhanashree madam, what is your views on 17(5)(c) and D? Safari Gifari ಎಲ್ಲ ಮುಗಿತಲ್ಲ?
Yes, sir. Just re-looking at 17(5)(c) once again. Works contract service when supplied for construction of an immobile property.
ಇಲ್ಲ D ನೋಡಿ.
Goods or services or both received by a taxable person for construction of an immobile property other than plant and machinery on his own account, including when such goods or services or both are used in the course of furtherance of business. Goods. So if there are goods or services used for construction of immobile property, then that will not be. But what could be the other credits?
But this land is used for putting up the building. The land by itself is not used for any activity.
Correct.
So credit is not admissible. Any other views?
Can on his own account be looked at here, sir, saying it is not for his own account?
He's only putting up the building. It is putting it up for somebody else. Opposite of own account is others account.
Yes, sir. Input tax credit difficult. Not possible.
Okay, if somebody, any other views, please? Input tax credit.
Sir, what is received is leasehold rights and not the land. It is the property which is received, not the thing.
For input tax, you're addressing the question of input tax credit.
Yes, sir. Yes, sir.
See, we are looking at the building that is constructed on leased land.
Okay.
So So is the lease of the land a service for construction of the building hit by clause D?
Also, for lease of the land, there is again no like whatever he's getting on lease, he's not paying tax on it. So there is no input tax credit to that extent because of notification 12.
Sir,
What
4/19.
he gets is only for the what he uses for constructing the building. So that
Sir, this 4/19 is Jatin sir, this 4/19 it will be not be applicable, na, sir, because that is only for the private models, not for this GIDC
Correct.
model.
Correct. Mylar?
Yes,
Yeah, ITC.
not allowed.
Okay, next 2 points to consider. Do we have time?
Yes, sir.
Yes, sir. Yes.
Suppose we are building a effluent treatment plant. Will the land also become plant and machinery is one question to consider. Secondly, lease premium, is it capital expenditure or revenue expenditure?
capital expenditure.
Yakama,
Deferred revenue expenditure.
deferred revenue is not there, no?
No.
Dhanasri madam, yake capital?
KSL ಹಾಕಿತ್ತು sir, it is capital asset.
No. See, can you, if you return the 99 years, after 10 years, if you return back the land, will you get refund? You will not
No.
get refund. So this money is gone. It's an expenditure which you are amortizing for matching concept purpose. Otherwise, it is not, it is revenue expenditure.
Okay.
You have not capitalized the expenditure. So we have to go into whether it is capitalized. If you treat it as revenue expenditure, you're safe on credits.
Oh.
About that, any comments, anybody?
But anyway, there is no credit on that, no, sir.
If it is capitalized, then only that restriction. To the extent of it is charged off, there is no restrictions. Sir is saying in that line.
So,
But there is no credit on that, no, because my lease is exempt under notification.
Your lease is exempt, but you have constructed the building, no? So even you are giving the right on the building.
No, madam.
so
No. In
benefit.
assignment, if you pay any GST, you said on this we have to advise clients to pay GST. Can they take ITC? That's what we're talking about. You said 17(5)D will get affected, but if it is revenue expenditure,
The building itself will make it revenue
and a
expenditure.
building, madam, the land lease assignment charges on that you have paid GST. Can ITC be claimed on that?
Where I have paid GST, sir? Like when
No,
I'm
madam,
getting the land on lease.
No, 1 minute. Lease, you don't pay any GST, but the lessee gives it to the assignee, like this GIDC case. And there, your advice is that please pay GST, don't fight this. This judgment is not a good law. If you pay GST, suppose I am taking it from you, can I take ITC of that?
The assignee.
I am the assignee, you are the lessee. If I take it from you, can I take ITC saying it is revenue expenditure?
The benefit of enduring nature principle will not hold.
But is this an enduring benefit? There's no realizable value on disposal.
I think the assignee can take the input tax credit. The assignee can't take this.
Think about, give it some thought. I know it's not fair to give 5 minutes and say come up with a view. It's something for you to give it some thought. if the view is compelling, now I'll give you a third perspective. Anybody else on assignee, can they take ITC? Dhanashree madam is now convinced. Where are other?
So initially we were talking on the assigner taking ITC, no sir.
Assigner
Assigner,
may not pay tax. Lessee will not pay any tax because of entry 41. The assignee is the one in question here, because the entire case of GIDC is that GS output tax is payable by the lessee. Now we are saying if the assignee can take credit, who is the so-called sublessee.
but the tax is on the lessee, no sir.
Adema, he is
And he
paying
assigns.
forward charge, ITC to the assignee, alva.
But can he use ITC while paying the
He may
forward?
not have, see, he won't have ITC to begin with. If he has some other ITC, he can use it on Kannada to pay the, but the lefty will pay output tax. The assignee, whether he will take ITC is the question now. Assignee is hit by 17(5)(d). Then we went on to see whether this expenditure is actually revenue expenditure and not to be capitalized. Even if you amortize it, it is not to be capitalized. For example, you treat it as revenue expenditure, disallow it in your computation statement, and carry forward to next year and claim a deduction to the extent of some portion of this.
But even here, how does it matter, sir? Like for the assignee, whether it is revenue expenditure or capital expenditure, it is not an immobile property.
Illama, 17(5)(d) will affect the assignee is the first point we concluded. To come out of 17(5)(d), there are only two carve-outs. One, it should be plant and machinery, or it should be revenue expenditure.
But assignee is not constructing, no, sir.
Assignee only will construct, ma. He will also construct.
Okay.
If I'm planning to construct, you build one godown, I will build 5 godowns in that land.
Okay.
See, there is this thing of theory of accretion, what we always keep saying in works contract. If you build something on a leased land, what you have built will also go into the land.
So I'm thinking there are two kinds of input tax credit that the assignee is getting. One is for paying the tax to the assigner. Second is for construction, if he's constructing.
We are only discussing the payment of tax to the lessee or the assigner.
That I think should be eligible also, because that is not for, he's not constructing, he's just paying that money for getting the.
No, but is it, suppose you treat it as capital, you capitalize it, then it is a service. Why did you, this is the advanced ruling of Hyderabad also, to say that you paid land lease charges only to put up a building. You want to use the building, you don't want to use the land. Give it some thought, give it some thought, give it some thought.
Interesting.
Next consideration, I have only 2 points to bring up for everyone's consideration. Next point is, can I say therefore assignment is not a supply, because that question was raised here, was not answered in this decision. We'll go back to transmission and subrogation and all that we discussed earlier. Assignment is not in any of the 8 forms of supply. Can we say we won't pay tax on this? GIDC or no GIDC, no tax will arise because assignment is not a supply, and that question was never answered by this decision, even if it gets overturned. Any views on that?
But how are we saying that it's not one of the 8 forms of supply, sir? Because assignment is.
As we discussed earlier, Lama. Earlier, Mailar's point was brought up, saying agent generis cannot be used. Transmission is not transfer. So therefore, assignment is not any of the 8 forms.
But we also discussed that assignment is is like lease only. Is like.
No. We didn't say that. We said lease is different. Assignment is not lease, because to sublease there was never a right of retransfer given to the lessee. So right of retransfer will only make it a sublease. There is no privity of contract between lessor and sublessee. Therefore, assignment is not a supply. That is another point to consider. The third point, can I see, as you know, in real estate projects, I can do JDA and JDA is exempt in residential conditionally. In commercial, it is not exempt, it is taxable. Can I do lease instead of JDA? Can I do lease instead of JDA? Because the GST and stamp duty payable on JDA is the launch price basis. But in the case of lease, GST and stamp duty payable is on average annual rent.
But in JDA, the proper building, the constructed property rights belong to the developer, no, sir? Unlike in lease where
Correct.
he will lose
In a
it.
lease also, the lessee will construct a building on the owner's land, and the constructed building will belong to the lessor
Landowner.
come developer, lessee come developer. ಮಾಡಬಹುದಾ? See, in commercial JDA, payment of GST on development rights is affecting IRR. In a non-RERA project, GST on development rights affects the cost of development. So therefore, there is no motivation to pay tax on development rights in both these cases. Is it possible to do JDA without doing JDA?
So
Ultimately, what is the purpose of a JDA is that the landowner does not terminate the agreement and evict the developer. So developer should have some hold in the property. Although lease, since lease is superior to development rights, the developer can never be kicked out of the site. He will complete the structure, get OC in his own name, and then do a partition. Think about it. I'll leave it at this.
But it is too risky for the landowner, no, sir.
No
He'll
risk to the
give 90
landowner. You only lease allanapa.
lease 99 years if I give
Why, if you want to do JDA, why you want to give it for 99? Give it for 10 years. Anyway, 3 years you'll finish construction.
Okay. So 10 years lease, then after
10
the
years
10
lease.
years, then it will come back because of the accretion concept. It will come back to the landowner. Then the developer will be in problem.
In the 4th year, when you get OC, you go for termination of lease agreement and do compromise deed.
Okay.
Alva?
But it will be at the mercy of the landowner, no, sir. If the landowner does not agree for this mercy, we are having one more MOU to bind him to do this compromising.
You can have any number of MOUs. If the developer does not go in for this arrangement in the 4th year, the landowner has to wait 6 more years and he will happily get the full building free of cost. Correct?
Correct.
Now, landowner is safe. Why is developer not safe? Developer is anyway in possession for 10 years. So during these 10 years, he wants to get perfect title for 60% rather than getting imperfect title for 100%.
Perfect title.
So he will go for set compromise in year 4 or 5.
Sir, in Delhi and all, like they follow this kind of
So
sir, like how
compromise,
we
yeah.
Sir, in North India, like we have seen, like how we follow JDA in South India. We have seen in few cases where they are following this lease model, where they will lease the land to a developer, and then he construct the buildings, and accordingly the agreements are entered with the buyer once the construction is completed, and landlord is also made as a party of that agreement, and it is given for a specified period, might be whatever the terms they decide, and then the buyer will be only the owner of that property for that period. So is it something we are trying to understand that kind of model, sir, here? Or
See, you're right.
yeah.
You're right. See, in entry 16
yeah.
itself, wherever we see development rights, it is always talking about FSI
Yeah.
or lease.
Yes, sir.
See, in Noida, it's always leasehold land that is taken up for JDA. Freehold land is common outside.
Yes, sir.
Leasehold land also you can do JDA.
Yes. But that practice we don't find here, sir. Generally, I have not seen as such in South India,
No, because
especially.
we have more freehold land here. We don't have residential leasehold land in South.
Okay.
Sir, as part of this compromise agreement, exchange of rights agata, sir. Return of right and obtaining
Yeah.
ownership. Huh?
Yeah.
Okay.
So this judgment is relevant for us to evaluate innovative ways of doing transactions where GST incidence makes it unviable.
Sir, there should be a separate notification for assignment itself, sir, or separate.
ಅದೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳೋದು ಅದೆಲ್ಲ
Sir, in this compromise arrangement, you said there is an exchange of right. I think there is an exchange of also property, no, sir? It cannot be right because the property has come into place.
You're right, you're right. There is a compromise, there is an exchange. Instead of having a imperfect title, developer has an imperfect title on 100%. The landowner has perfect title only on the land. Therefore, a compromise. Compromise is not consideration. We have Circular 178 itself.
Yes.
Sir, is it like it is returning the leasehold rights and getting the full title to the immobile property?
ಅದೇ compromise ಅಂದ್ರೆ ಇದೆಲ್ಲ ಏನೇನು ಮಾಡಬೇಕೋ ಮಾಡ್ಕೊಳ್ಳೋದು. At the result of the compromise, this fellow will have 60% of the land UDI and the building. That fellow will have 40% of the UDI and the building.
But it is not through a conveyance deed, sir.
No, it is a conveyance deed, but not through a JDA.
Sir, double taxation ಆಗಲ್ಲ sir ಇಲ್ಲಿ?
ಎಲ್ಲಿ ಮೇಡಮ್? ಸಿಂಗಲ್ ಆಗ್ತಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. Like there will be two transfer ಆಗುತ್ತಲ್ಲ sir. One is lease right transfer ಮಾಡಿ.
Lease is for 10 years.
ಹಾ.
Every year lease amount we have paid GST.
Yes, yeah.
Okay, no?
Now again you will enter a compromise. Yes.
So on GST on lease is paid for 4 years. Suppose you are saying 1 crore per year. On 4 crores you paid 18%.
Correct.
And on compromise you didn't pay any GST. Alternatively, what you would have done on the value of TDR, you would have paid tax in a commercial JDA. Okay, alva?
Yes, sir. But again depends residential or commercial. Again it depends.
Residential like ಬೇಕಾಗಿಲ್ಲಮ್ಮ.
No, because at least that's what I'm saying. It may not be for residential, only for commercial we can think on.
No, it is only for commercial and only for and mainly for non-RERA.
Okay.
Sorry if it went out of syllabus, but
no, sir. Good new thought process.
We're getting to learn, sir. Sir, ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ sir, assignment will it cover under supply?
No GST on assignment.
Because it doesn't get covered under 8 forms, sir.
ಅಷ್ಟೇ.
Sir, one discussion about entry 41, sir. Can we discuss that, sir?
ಹೇಳಿ.
Sir, ಅಲ್ಲಿ entry 41 ಅಲ್ಲಿ
10 ಗಂಟೆ ಆಯ್ತು, ಎಲ್ಲರೂ ಟಿಫನ್ ಮಾಡಬೇಕು, ಮನೆ ಕೆಲಸಕ್ಕೆ ಹೋಗ್ಬೇಕೇನೋ?
If everybody are okay, we'll discuss. ಇಲ್ಲ ಅಂದ್ರೆ
maybe we'll continue.
Sir?
ಅಲ್ಲ ವೇಣು ಇಲ್ವಾ? ಧನಶ್ರೀ ಮೇಡಮ್.
Yes, sir. 5-10 minutes we'll discuss and we'll close.
Okay.
Sir, entry 41 ಅಲ್ಲಿ last limb ಅಲ್ಲಿ it says or the developers in any industrial or financial business area ಅಂತ ಹೇಳುತ್ತೆ sir. So ಅಂದ್ರೆ is it when I mean so non-government also gets covered ಅಂತ ಆಗುತ್ತಲ್ಲ sir ಆ part ಅಲ್ಲಿ?
Not sure.
So, and also it is a conditional exemption, no? So they say that if there is a change of land use idre, then agreement itself should include that clause that everybody is jointly and severally liable to pay anta ಬರುತ್ತೆ sir ಅದರಲ್ಲಿ.
In entry 41 ಇದೆ.
ಹೌದು ಸರ್, ಹೌದು. So assignment doesn't get covered in this entry, alva sir, because liabilities can not get transferred through assignment, alva sir.
Yeah. You're right.
So the last limb says that to the industrial units or the developers in any industrial or financial business area. So the granting of long-term lease of 30 years by the developers also gets covered in this anta agatala sir.
If you're granting development right, but if you're entering into a lease and you are deriving development rights, how will it cover under 41?
So what exactly, how do we read that last part of the entry, sir? I could not understand.
No, I think we'll take it up offline because
Yes, sir. Okay,
already
okay, sir.
reached 10 o'clock and
Okay, sir.
Dhanasri, madam, over to you.
Thank you, sir, and thank you, everybody.
Thank
Very.
Thank you.
Thank
Thank you all.
Thank you, madam,
Thank
for the
you.
good presentation. Thank you.
Thank you.
Thank you.